supervised visitation. Petitioner was ordered to deliver the child to my client on April 22nd at the Sacramento Police Department. And the order provides that if she fails to deliver the child, the Los Angeles District Attorney Child Abduction Unit is appointed to locate the whereabouts of the child, take possession of the child, and deliver the child back to my client. Petitioner failed to deliver the child on April 22nd. Instead, she went on the lam with the child and 3 days later filed her petition in this case. So she and the child are currently in hiding. She has been withholding the child from my client since February 23rd, despite the valid court order granting my client sole legal and physical custody. He's not been able to see his son in over 2 months. So we're asking this court to issue an order domesticating the April 22nd California order, a certified copy of which.
That's because I got Sean Wexler back. He was on his hiatus. That's why I was having all technical difficulties. Now he's back and we're back.
Which was filed along with our motion to dismiss, so that my client can work with law enforcement here to retrieve his son. So hopefully more court and law enforcement resources will have to be devoted to this, all because Petitioner wants to keep the party's child away from his father and is trying to pit one court against another so that she can get away with that. We're asking that her case be dismissed and that Petitioner be ordered to pay all of the attorney's fees that my client has been forced to incur in defending against Petitioner's latest attempt to evade the California court orders. And we're asking for those under both 1913-4A10 and 915-14.
Ms. Holmes, now it's your turn to respond to her motion. Okay, so this isn't you making your case. This is you responding to her motion of the orders in California and things like that. Go ahead.
Yes, and I will also attach the additional evidence. First, I wanted to say that the things that she is saying is definitely hearsay. I have spoken to all law enforcement in Sacramento. I have spoken to the Child Abduction Unit in Los Angeles. I would like to start by saying I would never relitigate the same issue. The violence that happened on February 6th, when I immediately came here, my ex-husband has manic issues of violence. He is known to be violent, and I have a history of him being violent. On February 6th, when he harmed our son, I told the Sacramento police that we were fearful because he has broken into my house and abused me before. I said that we were fearful, and that's also provided in the police report from even 2017 that I sent in evidence. The police told me that it was okay. That
objection to hearsay, Your Honor.
Okay. I can't hear what.
I have a police report, and
okay, so hold on. Hold on. Okay, so what you need to respond to is like her motion. It's okay. Not, it's not testimony about anything that's happened, so I can't hear anything else anybody else said.
Okay, so when we were transferred, we came from California to Georgia on the 6th, and then we're made to come back. DFAX was even contacted. He contacted me and told me if I didn't return back to California, he was going to find a way to take RJ and have somebody harm me. We came back and then we litigated there. Los Angeles County does not have jurisdiction over the original violence or any at all, because he doesn't live in Los Angeles County. The only person that is forum shopping to make sure that the violence is heard in a venue that is beneficial to them is Rashawn Holmes. He is an athlete that feels like he is above the law and can get his way. He is on record violating orders. We have final orders that we fought for. The person that is making these orders for, as far as the orders for April 22nd, those orders were made after he already threatened to call the Child Abduction Unit in Los Angeles, and I called them first. Rashawn does not live in Los Angeles and never has had a lease in Los Angeles. I used to live in Los Angeles. I've been a resident of Georgia since November. The person that made those orders is a private mediator that gets paid $2,000 an hour by my ex-husband. He is a mediator to the stars, and he is known for giving rich men their way. Rashawn lied to the Sacramento court. When I did do the domestic violence restraining order on March 9th, I contacted the district attorney's office before I even did so, because and her saying that he hasn't seen Rashawn and RJ in 2 months is not true, because after the 6th, I complied and let RJ go again from the 20th to the 23rd of February. So he returned again after the abuse that happened on February 6th. And when he returned back to me, he said that he was still afraid to go and that his father—
Objection to hearsay.
Yeah.
No, we have CPS workers.
No, I can't hear what they said. You just have to state factual thing.
Okay, factual things is that my son came home and said that he was—
Objection to anything that the child said.
Yeah.
Okay.
So it's like, so what she's talking about are court orders. You know,
Okay, so and the court order from March 9th was made after there was more alleged violence based on the things that was said to me by my child. I then took that information to the proper venue. They, the police in Sacramento told me that—
Objection to hearsay.
all right. So I can't hear what the police said.
Okay, yes, but I was under the belief that I had jurisdiction in Sacramento, and so did the judge on March 9th for the additional violence that took place. And they issued me a restraining order. This motion to dismiss is what he always does, because he has the money to get a lawyer and submit anything into the court. He tried to motion to dismiss the March 9th DVRO 3 times, and the judge— exactly what we're doing now, and the judge dismissed it. When we did finally go to court on March 30th for extending the DVRO, he lied and told the Sacramento, California court, which is in our orders, that he does not live in Sacramento, even though that's where he currently is and that's where he was served. So forum shopping, in order to get the forum in your proper, where you want it to be heard, you lied to the court and told them that you did not live in Sacramento. And you do.
Okay, so don't talk to him.
I'm sorry.
That's okay.
And in order to— one second. I'm sorry.
Okay.
Morning, everybody. Third time's a
So
charm.
in an effort to continue to get his way— I'm sorry, I had to move around because my son was— in an effort to get his way, he is doing the same thing that he did in Sacramento, because he just doesn't want the violence to be heard. So after March 30th, him and his family began attacking me in media, and we were told that it is totally okay for us to go back to our home in Georgia. We were only there on visitation purposes. After March 30th, after he lied and told the judge that he did not live in Los Angeles, we spoke to the California domestic violence advocate for the Secretary of State, and I filled out a good cause notification, and I filled out a safe at home program which is a domestic violence program in California, in order to make sure that I lawfully came back to my home in Georgia. We were in domestic violence shelter from March 30th. I even gave him the opportunity to meet with RJ, with a mediator, to speak about the things that RJ was saying about what happened to him. He refused. He is only interested in controlling me, controlling RJ, and controlling the situation. Also, the violence has taken place here. A DFACS worker came to speak to RJ separately, and this is about my 6-year-old saying that he is afraid. And if that wasn't the situation, then the DFACS worker wouldn't have issued us a safety plan. Also, the police, the Sandy Springs police and the Fulton County police were contacted. I showed them those orders, and the orders from a private mediator that is privately paid on a fiduciary in a fiduciary fashion by one party. Those are not orders by a superior court judge. That is not a superior court judge. I complained to the commissions on judicial performance, and I filled out a appellate and a motion to dissolve the stipulation. What we're in is a mediated stipulation by a hired neutral, who is not supposed to be making changes to our stipulation, as you see from the letter that I received from the judicial commissions of performance. He is not a judge. He is not a member of the bench, and he is not a member. And the orders that he creates are paid orders by $2,000 an hour. The stipulation, that is the only thing that the evidence that I wasn't able to provide. This, and he is blatantly, if I've done something wrong, it's because I'm just trying to protect our son, who says that he's afraid of you. He is actively lying in order to, I'm sorry. He is actively and purposely forum shopping in order to get out of each court. He lied to the Sacramento court to say, oh, I don't live here. And now here he is saying, oh, a superior court judge. If I called the Los Angeles court, and they know nothing about these orders. This is a mediator that is a mediator to the stars. He gets paid hourly by my ex-husband in order to give his way. If he stops giving his the mediator that made these orders about abduction, and this mediator has also done all different types of unlawful practices in order to give my ex-husband his way, because he is a rich athlete that feels like everything is supposed to go their way. I have been in compliance with everything. We have been divorced since 2019. I have been in compliance with everything that lawfully that I was supposed to do. I would never do anything unlawful because I don't even have the millions of dollars to fight in court. He does. What I'm saying is true and provable down to each letter with a piece of evidence. I wasn't able to provide all the evidence this morning. I was planning on doing all of that before the 13th, but to say that the violence didn't happen in Georgia, it absolutely has. He and his family members are on a line actively threatening me, showing guns, and I have text messages of him threatening my life the day that I served him. I served him. And he was served to the best of my ability. I served the document that I received after our hearing on Monday. I also checked with domestic violence advocacy here just to make sure that what I'm doing cannot be considered forum shopping, because that's not something that I would ever want to do. He is the one that now provided evidence saying that this superior court judge ordered, the Los Angeles Superior Court knows nothing about the orders that the mediator Thomas Trent Lewis has issued. Thomas Trent Lewis is not a member of the bench, and the orders that he has created, he is a neutral hired by a law firm.
So this says that Judge Lewis is retired.
He is retired. He is not a judge.
But, well, so I mean, you can tell by my accent, I'm not a California lawyer, and don't
love it.
Think I practice law in California. Wouldn't even try to practice law in California. But I will tell you that.
Thank you, Tink. I much appreciated. You're the best.
They're retired judges and senior judges here in Georgia that would take some offense to saying that they're not real judges. So.
Oh no, I'm just. I apologize, Judge. Definitely.
No. I'm just saying. So this.
I'm speaking in terms of this case. He is not. I'm sure he spent time on the bench. He is a retired judge.
But that's what I'm saying. And it looks like. But so let me kind of get you back on track. All right, if you don't mind, Ms. Simpson.
Please.
Okay. So it looks like these are orders that are signed. That have been submitted. Findings after a hearing, federal custody support. They're orders that has his electronic signature, and it looks like they were sent to a couple different lawyers.
Yes.
One of these lawyers, yours. So it was on one's January the 3rd. There's another one that was April the 22nd. So tell me, what is it that you have to say about the April the 22nd? Because the way I'm reading this, you correct me if I'm wrong. Because, like I said, I like to tell people, I know when I open my mouth, Mr. Holmes, you gotta keep your camera on, Mr. Holmes. Hold on, wait on Mr. Holmes, because we don't know if he's there, and he's got to keep his camera on, because this is akin to walking out of my courtroom when you turn your camera off.
Your Honor, I don't know what's going on with my camera. I'm still here.
Did you get a phone call? Sometimes you got to, you got to like.
No, ma'am. I went on mute and the video cut off, and I'm hitting to start the video now, and it's not starting.
All right. Does it do that if I say ask to start video? There you go.
Okay.
All right.
Thank you, ma'am.
Yeah, no, sir. That's fine. So, so I'm looking at this April 22nd order. Okay. Are you familiar with it?
Yes.
Okay. So it was electronically signed by Judge Lewis on April 22nd. And in here, okay, so this is where I'm kind of having some, because I can call out, I don't know what time it is out there, but I can call out there. It says, let's see, I want to make sure if you got it in your hand, let's see, okay, there's a case number. You're the petitioner. Mr. Holmes is the respondent, or plaintiff and defendant. So it says, respondent shall select 3 professionals and monitors to provide said names to you. You shall then choose 3 of those professionals and monitors as you may use for your visitation. So it looks like at some point, you're supposed to have supervised visits and pay supervisor. Right? I'm sorry,
Yes.
he's going to pay supervisor. So this was on the 22nd.
Yes, and that was made.
So this was, and it's signed by Judge Lewis. Okay, so hold on, back up. Wait, listen, go back. Sorry, these are all scanned in. Let me get back to. Oh, there it is. Okay, it's marked. All right. So findings after a hearing. There was a hearing. The hearing proceeded at April the. Let me share my screen so you can see where I'm at.
No, I can see. I know what you're.
Okay. So it says it was April the 21st at 8 a.m. Good for Judge Lewis getting up that early. I like it. All right. So 8 a.m. Let's see, Ms. O'Brien appeared at 8 a.m. on behalf of you, filed a substitution of counsel because you said you wanted to, I guess that's pro se, but pro per. So you wanted to represent yourself. So there's modification, custody and parenting time. Here it said that sole legal and sole physical custody was awarded to Mr. Holmes.
Yes. And after I contacted the family, the Stanley Moss Family Court in Los Angeles, and also contacted the district attorney's office in Los Angeles, orders that are made by a private mediator fiduciary, he cannot change our final orders. They're supposed to be a neutral, and he does not have.
This is a court order. So like I said, I wasn't there.
No, that's a smoke alarm that needs to be fixed.
This is a court order. So that was a hearing.
And that was made, and it's because, and mind you, the defendant does pay Judge Lewis. And the night before that happened, I made them aware that we were in a domestic violence shelter and how we were being treated was unfair. And I will be alerting the presiding judge that presides over this stipulation, because everything that is put in our stipulation, and if there are changes made, is supposed to go through the actual Stanley Moss Family Court. When we have Zoom court, they're similar to meetings. So that was his attempt to, the night before, I emailed them and told them that we were in a domestic violence shelter, and that I was still being threatened, because of course the defendant is not going to say what he's been doing. And it even down to the violence that took place with our son.
So let me see what's so. I don't know what kind of athlete he is. I don't care.
But really that was his attempt.
I don't care. Famous, I'm famous. I'm a big deal. In Atlanta, I'm a big deal. Okay? So he ain't a big deal. Ain't nobody out here a big deal but me. I'm kind of a big deal. All right?
Yes.
And once I guess he's hold on. He's probably tall, so he probably plays basketball. And I'm not impressed with that. I'll tell you why I'm not impressed with that, because I have played basketball longer than LeBron James, but it doesn't mean he's better than me. Okay? So bring LeBron out here and I'll whip you up too. I played basketball longer than him, so don't mean he's better than me. Okay, so all that athlete stuff, I don't care.
And I'm glad you said that, Your Honor, because honestly, we can't act like that aspect doesn't exist, because that is one of the reasons why I'm getting threatened, and that's one of the reasons why he wants to stay in private court, because once the violence.
So I don't care. So don't worry about talking about money. I don't care. I don't care about that. I don't care who he is, and I'll meet you on the basketball court, Mr. Holmes. I'll tell you. but I'm just telling you, okay? That's it. So I don't care about what I care about are these allegations of violence. And like Ms. Simpson had brought up, when has Mr. Holmes been to Georgia and commit? Because here's the thing, something has to have happened in Georgia. So when's Mr. Holmes been to Georgia and been to Georgia and committed acts of violence?
Yes, and what I'm going off of for that is I look to see does he have ties in Georgia? Does he work here? And did the violence happen in Georgia? He absolutely has threatened me. I've received the threatening here.
But has he been to Georgia to threaten you?
And he also put a tracking device in RJ's bag that we had to get rid of. And RJ's he gave him an iPad and he was tracking our every move, which is how he knew exactly where we were February 6th. So the violence when
you were in court on April the 21st, you were there, right? Yeah, were you there?
Yes, ma'am.
Okay, so you heard this judge say all this, right?
This is Dustin from Streamlabs.
Yes. But
Right.
I knew that it was based on the judge. That mediator and private judge and Rashawn are friends. He pays the bill. And when I emailed to the night before that court, expressing that I believe that the judge just wanted to, or the mediator, it's his job to give Rashawn his way, because he's the one that's footing the bill, and Rashawn is just actively trying to save face, because now the private court is how he can keep his history of abuse quiet. Once things came to public in Sacramento, that's when he began. Things were in the media, and the threats came harder, and he was upset. He is trying to keep things in the private sector, which only happens in California, New York, and Nevada, where you can even have a private mediator make changes to your stipulation. But that's what he's trying to do, because he wants to protect his brand. He wants to protect things like that. He doesn't want things to be able to be seen in the public specter of the court. But if there is allegations of abuse, it should not be covered up by any private court process. I'm just
trying to get you back focused on what has happened in Georgia.
Yes. So what has happened in Georgia, and that's why I immediately contacted law enforcement here. If I was wrong, law enforcement, and I will comply. If I'm wrong right now, I will comply. All I'm doing is trying to protect RJ. So
I understand. And on here, you're important, he's important, but this child is important. So, so Ms. Simpson, do you have some contact information for these folks out in LA? The child abduction.
I've not spoken with the child abduction unit in Los Angeles. I have contacted law enforcement here, and I've been in contact with his attorney in California. Not that it's important to the issues before us, but I've been looking for it. I do have a document that Ms. Holmes signed agreeing to Judge Lewis being appointed as the private judge in this matter. As I understand it from Mr. Holmes' counsel in California, that is permissible in California to have a private judge appointed to make decisions in your case. The certified court order from the Superior Court of Los Angeles County issued by Judge Lewis is a valid court order. But again, that doesn't have anything to do with this case and whether or not the violence that Ms. Holmes is alleging actually occurred in Georgia, which it didn't. And you've asked her several times, and she's not giving you a straight answer about anything that's happened in Georgia, that my client has come to Georgia to commit any kind of family violence. So
tell me about that.
Rest again on my motion to dismiss.
Your Honor, I just wanted to make sure that I made it clear that I am saying that when I have contacted the Los Angeles County,
focus with me. What acts of violence has he committed here?
The harassment, the threats, the stalking of having a tracking device in our son's bag. And even as now, this is our safe place. This is our home. when the so the acts of violence that took place here, the moment that RJ was hit, RJ came here with a bloody knot on his head. And here his father is actively threatening, even with this mediator trying to, but actively even email texting me, him and his family are saying things, threatening and harassing me online, and not to mention his fans, who he insulted me on his Twitter and has his fans attacking me daily, sending me death threats, calling me a gold digger. He is him and his family are actively saying, "I'm gonna get you." Insulting me, calling, "I'm gonna get you. You have to deal with us." That's what his family is saying, that I'm gonna get you. You have to deal with us. And this is, I expressed these things, and for the thing of forum shopping, I told DFACS this. I told the police this. I even told the police the orders that were made by the mediator on the fiduciary standpoint. They said that I have.
Okay, when has he been here? How many times has he been here besides?
He comes here often throughout the year. He used to have a property out here, and he comes here at least 4 to 6 times a year. And he has a W-2. He has a Georgia W-2.
Okay, so
But that has nothing to do with family violence.
He probably plays here, whatever. So, but when he's been here, like, what has happened here is what I'm trying to.
Most of the things that have happened here has been electronic, with the, like I said, the stalking, the harassment, the harassment and the stalking happened physically, because he physically placed an item in our son's bag in order to track us. Then the harassment.
When was that allegedly done?
That was in February.
Okay, so it's February of this year.
Yes, ma'am.
Okay, gotcha. So let's back. So have you been to court in Los Angeles, Sacramento, wherever, California, on that issue?
On that issue, no, only about the violence to my son's head.
So you never brought up the tracker?
Well, I mean, I brought it up, but that was in addition to, like, I definitely brought it up, but that was in addition to, I want to make sure that I'm being completely truthful. I brought it up, but that wasn't the reason, like saying, oh, because I had bigger things to worry about, which is the violence. So I definitely brought up that we were being tracked, and as well as my previous lawyer brought up that that is stalking and harassment, that he put a iPad in order with the Find My iPhone on it so that he can know exactly our every move. And then the threats, I have the text message, the threat text messages, as well as his mother tweeting and said, "You're gonna deal with me."
But that's his mother. I just need to know about him and violence.
Oh, him. Well, I've received text on the day that I served him. I received a text saying, "Just wait," threatening text. I have that, and I submitted that as well. And that's what I have. I've sent those things as well. And when the DFACS worker did come and speak to RJ alone for 30 minutes.
DFACS where? DFACS where?
Not DFACS, I'm sorry. Here, Georgia.
Okay, so okay, got you right there. Okay, so what's your court date on that?
Oh, it's an investigation. DF's.
No, I get it. I did, because I sit down in juvenile court. So here, let me show you how juvenile court works. Okay, somebody makes a complaint. DFACS goes out and investigates, and then if it rises to the level of need to be looked at, you get a court date. So that's what I'm curious. What's your court date?
I'm not aware of my court date, Your Honor. I just
when did you make the report with DFACS?
That was Thursday. I want to say the 19th or the 18th, the 19th, and of April. And this, I also provided this in our evidence. The safety plan that was made by my caseworker was made on the 20th.
All right. So I got to focus you back on what has happened physically here in Georgia, because you said he did this in February, so that would have meant you would have been back in California. So what's happened here?
The threats, the stalking, and the harassment, the tracking device, and the threats on my life.
But he's
in
called you
order-
on the phone. But he's called you on the phone, or somebody's tweeted or snapped or whatever they did. They've done that, okay? But I want to know what. Tell me what you have a term. This is a court order. This is what and what Ms. Simpson said is that you're forum shopping, coming here because you don't like the court order that Judge Lewis did April the 22nd.
If you call, I've already put in a motion to dissolve that stipulation. If you call the Superior Court family, if you call the family court right now, they will tell you they know nothing about these orders. I promise you. If you call the family court, not Judge Lewis, not signature resolutions who Judge Lewis looks for, they will tell you that it doesn't even look like we have gone to court since 2019, because that's the last time we went to public court in the actual family court realm. And when I called,
I think Ms. Simpson said she submitted a certified copy to the clerk's office. So certified copies are when orders have been filed, they go to the clerk's office, and she paid money. He went by there, had somebody go by, somebody went by, got it, got a little stamp, a little seal, sent it to her. So she filed a certified copy here. So these are filed in there in Los Angeles. So somebody's not being completely honest with you or not looking deep enough. So see, it says at the top of it where it says electronically filed by Superior Court of California, Los Angeles, 4/22 at 2:17 p.m. Sherry R. Carter, Executive Officer Clerk by S. Baraja, Deputy Clerk. So it's like here, when Miss Free files something, it's that same exact thing on there electronically. So these records are in the clerk's file out there in Superior Court in Los Angeles. So
yes, and
I'm
when
still kind of trying to focus you back here because I still want to waste anybody's time. And since you don't have a lawyer, I'm really trying to give you a lot of leeway. I know Miss Simpson's getting frustrated with me, but she understands. So I just want to know what he's done here.
Yes, ma'am.
Because since April the 22nd, a judge, paid for judge, retired judge, brand new judge, whatever judge, because they do, I know they do, because they got all these, out there, they do this, private thing and people agree to it. So, and here we kind of call it like arbitration and things like that. So we'll do some things like that here, or judicially hosted settlement conferences. But what I'm wondering here is April 22nd, you were there, or April 21st, this order was issued on the 22nd. So why did you come back to Georgia and bring the child here?
I was already there. I was already here. I contacted all law enforcement. I was already here, and I was told that it was okay for me to come here.
Who told you that?
In our police report. I told the police that we were coming here, and I filled out a safe at home and a good form notification because we were in a domestic violence shelter. Okay,
so you've alleged these same things in a couple different counties there.
No, not the same things. The harassment text messages, these are new. Okay. I would never just keep doing the same thing. I'm just trying to let you know the history of violence. But these exact things that I'm arguing with you have not been argued in Sacramento, as far as the harassing and the threatening, because he just wants to be able to control and have me be in a place where he's not even going to be because he's about to get traded. But you want us to be able to travel around with a child that has ADHD and that is saying that you harmed him and is afraid of you. And when the DFCS worker came and spoke to RJ alone, she put a plan in place saying that there is present.
Objection. I'm going to object to hearsay as to what the defects worker said or put in a safety plan.
I've provided the safety plan for you all as well.
I still object to hearsay.
I got a feeling this defects worker hasn't reached out to Miss Simpson or to Mr. Holmes.
She has reached out to Mr. Holmes, and Mr. Holmes has not.
We don't know that because she's not here.
Oh, okay. I was just letting you know. She did tell me that she
objection to what she said.
So if we could get you back on, is there anything specific that he has done here? Did he come here and sit outside of your house? Did he come here and follow you around? Did he come here and stand in your front yard and scream at you? Did he come here trying to track you down?
Yes, well, not physically. He just I'm just gonna tell you the truth, and if it, that's the truth.
Yeah. Oh.
And so the truth is that he has threatened my life via text message, and that he has threatened to take RJ and have me never see RJ again, and he has tracked us and stalked us here, and that's what I have for here in Georgia. And
how old is RJ?
6 years old, and he has ADHD and on the autism spectrum.
Okay, so where is he at right now?
He's with me.
Okay, well, I mean, can you if I put this in a breakout room, can you put him on the camera?
Absolutely.
All right, so I can talk to him, Miss Simpson. You have any objections with me talking to him?
Nope.
Miss Simpson?
I don't.
Okay.
One moment, I'm getting him right now.
Okay, and then when you hand him the phone, I want you to leave the room, because I'm going to put him in a breakout room and I want to talk to him all by myself.
Sounds good. I'll do that right now. I'm gonna just put you in his room. How's that?
Oh, okay.
Do you want me there as well, Your Honor?
Yeah, you can stay. You can stay here. I'm just going to chat with him and see.
One moment. RJ, honey. RJ, honey, come here, baby. Come here, please.
Thank you, Tip Tickler.
Madam Court Reporter, we'll go off the record for a second. I will.
Hi, friend.
Big boy.
Are you gonna let him hold the phone for me? Or sit
Yes,
him down
I'm about
somewhere?
to put him.
All right, I'm gonna
What's
put us.
up, big boy?
Put us in the breakout room.
No, please sit down. Here.
Hey, RJ,
What up,
RJ,
big
be cool.
boy?
Tell him, Dad. Tell him to be cool. Talk with me for a second.
He ran. Honey, please come and sit down and talk.
All the proof you need right
Please.
there.
I'm sorry, I ain't seen him in
Please.
so long. He got so big on me.
He ran away because he doesn't like to talk on the phone to his dad. He can see me chasing him.
Okay.
RJ, please.
Here, I'll put us in the breakout room so he won't be able
Yes,
to see.
if because he's, like I said, he's actively afraid of his father. That's
All
why
right,
he
join the
won't
breakout room. Hit the little thing to join the breakout room. Be back, Mr. Holmes. Miss Simpson, Madam Court Reporter.
I don't know. What do you think, Mom? Do you think he just didn't want to talk on the phone, or he's scared of Dad? I don't know. I don't know what to think of this one, guys. Let me know. What is going on with this TPO? Let's speed it up a little bit.
She should come back in here. He's kind of shy. I showed him some magic. There he is. I showed him some magic.
There you go. There's Mommy's
Manning
phone.
the magician.
You can talk to her, and I'll give you a peppermint.
We outside of the breakout room though. You wanted to see my magic again, RJ? You ready?
I'll get you a peppermint.
All right, I got it. I'm gonna be showing everybody my magic though. Okay. Well, this is like the Wizard of Oz. I'm pulling back the curtain. You ready?
Yeah.
All right. What's this?
Oh,
Boom. Oh, let's see. There we go. That was magic, right, RJ?
yeah.
All right. You gonna learn how to do that?
And we saw Manning's.
Yeah.
And we saw Manning's.
All right. I want to see it when you do it. And your grandma
Judge cave.
is my superhero
That was
too.
the judge
and I
cave.
bet you grandma bought you that shirt.
Yeah.
Yeah. Grandmas are great, aren't they?
Yeah.
All right.
That kid's
So
a
you
millionaire.
can put your mom back on here.
Okay, kilo.
You all set?
Yeah.
clap
We just
for
say
Manny.
thank you. Nice to
Best.
meet you.
Thank you. Nice to meet you.
Nice to meet you, RJ.
Can I go play now?
You can go play now.
Go play.
Yeah.
Can I go
Thank
with you,
you.
RJ?
You're
Can I go
welcome.
with you to play? That's what I'm asking.
How about kilo?
It's so cool, dude. And to get an email from her, that was so cool. That made it all worth it for me, man. I was just telling Sean the other day. It's just makes it so worth it that she recognizes our work. It's great.
Are you sure? Because are you sure that you because once he gets back in that yard, it's gonna be hard to wrangle him back in.
I'm good. We'll go.
Okay.
We'll go back on the record, Miss Wilby. So here's what I want you to do, Miss Holmes. I'm trying to get in touch with California.
Mommy, I watched iPad last night. I'm so sorry.
It's okay. Please don't watch iPad at night again. It's
Sounds
okay.
like
Mommy's
a
gonna
good
talk
kid
to.
too.
Mommy's gonna talk to her friend now. But
Your turn.
my turn.
How about kilo?
Our dog. He can talk to friend too. Okay, go ahead and play with
Come
him.
on, kilo.
Sorry,
That's
I'm going
okay.
to the other room now.
That's okay.
Deanna, is there any way I can talk to him? I just ain't.
Oh yeah, you can talk to him. RJ, you want to talk to your dad?
No.
You sure? You want to talk to daddy?
No.
Why not? No, here you go.
No.
you wanna
We're
talk
not
to
good. We won't do this.
RJ.
We gonna do this. We gonna let him. All right. I put you on mute, Miss Holmes. Okay, so you need a second, Mr. Holmes? Mr. Holmes, you can turn off your camera and take a second if you'd like. Ms. Simpson, have you had any luck getting in touch with Judge Lewis for me?
I was able to contact the attorney in California who's emailing him now. She said that she thinks his staff doesn't get in until 8 a.m. out there, and it's 7:48 right now. So
How about then we take like a 10-minute break, okay? Give me put you and your client in a breakout room.
sure, that'd be
All
great.
right. Let's see. There's you and we'll put you, your client, in a breakout room.
Okay, yeah. I see.
And then so we'll take a 10-minute break, Miss Holmes. You may have to call him and tell him to swap over to the breakout room.
Your Honor.
If you're in the main room, just getting them to
Okay.
come back in the main room. That's in a breakout room. I didn't want to go in there.
Oh, okay.
I think Ms. Simpson's trying to figure out how to leave the breakout room. All right, Ms. Simpson, Ms. Holmes, you can turn your camera back on for me.
Yes, ma'am. I'm trying to turn my camera back on, but it's saying it was disabled by host. Are you able to hear me?
I can hear you. Hold on a second. Let's see. How about that? There you go. Okay. All right. So we're back on the record. Since Ms. Holmes and Mr. Holmes, I'm just gonna drag this out just a wee bit longer. Mr. Holmes, I don't know your schedule, so you can chat with Ms. Simpson, see if, I want a social worker to chat with RJ since I couldn't get a lot out of him. So when could you be here, Mr. Holmes? And Ms. Simpson, you're here. Don't worry about that.
Yeah.
Unless you plan on flying, when could you be here?
I'm out of season, so I can come to Atlanta whenever is required, ma'am.
Ms. Holmes?
I'm available at any moment, Your Honor.
Let's see, Ms. Free, hold on, she may be working on something else. Let me check here real quick. Ms. Free. Oh, she might have jumped off. Hold on a second. No. What about, let's see, because I don't want anybody to have to spend a whole bunch of. Are Mondays good for you, Ms. Simpson, like the 16th? Like that would cost you so much. I mean, wait, let me see. This one on Monday. I mean, it may be too short notice for you though, Mr. Holmes. I don't want you to have to spend a fortune to this one on Monday. Somebody else is going to hear. I could hear this Monday or the next Monday or the following.
I can do it whatever time, Your Honor. Whatever is faster and quicker for you, I can be available whenever.
Ms. Simpson.
I am in court this coming Monday.
Okay.
Following Monday would be fine.
Oh, let me pull up my calendar and see if I got something. Are you in court the entire week? By any chance?
No, just Monday and Tuesday, actually.
Where are you on Monday and Tuesday? Something you want to go to? I can get you out. I'm kidding. That's just broadcast. So let's see. Oh, that one's.
Available tomorrow.
I don't know if he could get here by tomorrow.
I can be there by tomorrow, Your Honor.
Let's see, Ms. Frame, see if Dr. Taylor is available. I'm waiting on. Let me see if I can.
What if there's court Monday and Tuesday is Wednesday, the 11th?
Let me see if Dr. or let me see. Ms. Free. Or I just text her and see if she may have stepped away from the. See if I just want to get Dr. Taylor available because tomorrow I have like this. I have TPOs all day, but I could probably hear it first. Wonder if I can. Miss Free, I'm gonna mute this while I say, get back to your desk.
What up, Judge? Yeah, text me. All right, cool.
Is that somebody's smoke detector going off in the background? I just want to make sure I'm not being paranoid about the one that I just changed the battery in my house last week.
It is me, and I cannot figure out which one it is, and that is what I'm going to be doing as soon as we get off of here. Sorry.
Okay.
It's
No worries. I just wanted to make sure it wasn't me.
I'm sorry. I can't find which one in this basement it is.
Oh, you're fine. Don't worry.
All right, so there's Dr. Taylor, the world famous Dr. Taylor. So Dr. Taylor, I've got a 6-year-old little boy. He likes the magic when I pull my screen down. I'll just go ahead and give you that hint. So if you don't know magic, you're not going to impress him. But are you available tomorrow to chat with him if the parties come in?
I am. I'll
Okay.
be here all day.
Okay, so do you mind putting that on your calendar? So, Mr. Holmes, I hope that's not too much of a strain for you, but
No,
they
ma'am.
open the courthouse doors at 8:30, right? So I can, we could, Ms. Simpson, can you be here at the courthouse at 9? I'm not sure where your office is or where you live, if there's traffic, but okay. Or we could probably do an order and get you in a little bit earlier if y'all wanted to come in a little bit earlier.
That's fine with me too.
What do you think, Dr. 8:30, Dr. Taylor? We just need to order. I could do an order and you guys can come in at 8:30 and I will meet you there at the courthouse, courtroom 8G. Mr. Holmes, hopefully you can make that happen. If something comes up, let us know. Ms. Holmes, just bring RJ. Dr. Taylor will she's got her PhD in psychology, so she'll talk to him, probably do a little better than me because I can't keep my own attention sometimes, much less a small child's attention. Okay. Is that good?
Yes.
Okay.
My only question, Your Honor, is does this mean do I get to see him at any point during this, or do I still have to stay away?
Well, I'm just gonna figure, Ms. Holmes will bring the rest of her documents. I'm gonna finish looking at Ms. Simpson's documents. If she has anything else, she'll send it to me, and just waiting to hear back from that court out there in California. So, but I'd rather Dr. Taylor talk to him since that's where she's trained in.
Yes, ma'am.
You know, that'll be better. So I guess you should probably, sorry. I mean, I hope it's not head to the airport now. Maybe you and Ms. Simpson can make a plan and I will see y'all at 8:30 and we'll do an order and we'll send it that they will let you folks both in at 8:30. So that means you can get at the courthouse, 136 Prior Street, Mr. Holmes. They will let y'all in early, but you got to have my order with you, okay?
And is there a physical copy of the order or an email copy?
An email copy is going to be fine. Well, so we'll email you a copy, just print it out, and the deputies will be, in the morning, I'll give a copy to the deputies, and the deputies will be expecting you, and Dr. Taylor will be there. If she could just swoop RJ up and go talk to him while we have the rest of our little hearing. Is that okay with everybody?
Yes, ma'am.
Yes.
Okay, so it's 136 Prior Street, Ms. Holmes.
What courtroom or what floor?
8G. 8G as in George. So when you come in 136 Prior Street entrance, you get on the elevator, go straight up to the 8th floor, get off the elevators, make a left, go through the double doors, they'll be right there. Can't miss it. Right into the courtroom.
Okay.
So make sure RJ eats a little breakfast so he'll be focused and be able to talk to Dr. Taylor. She's got a little attention problems, Dr. Taylor, but you're pretty used to that with the rest of this.
I have all the judge problem as well, Judge.
Right. Thank you so much, Dr. Taylor.
No problem.
We'll see you
I
at
look forward to
8:30.
seeing everyone tomorrow morning.
Thank
Same
you.
here.
So, Madam Court Reporter, I can Zoom you in unless you want to be there, and you can record it from there, or you can physically come to the courthouse.
It would probably be better for me to appear over Zoom if that's okay with the parties. I think you're in DeKalb, right? So that's about an hour or so away from me, plus traffic.
Yeah, no, I'm in Fulton, but see.
About the same.
Yeah,
Okay,
so launch traffic, but you're right. So that's fine. We'll use this same Zoom link. So you could just jump on, because now they got these whole new cameras, not fancy California, so you guys don't get excited, but we got our new cameras, our new microphones, stuff like that. So I'll be able to Zoom you in, and the acoustics now are great. Now they got new microphones, so you should be able to hear everything. But we use the same Zoom link, and I'll log on to it maybe 8:15 or so, and then
Okay.
I'll let you in, and we'll contest it out and make sure it works.
Okay, great. That sounds perfect.
Thank you.
All right, here we go. You think that's all I have? Honestly, let's rock and roll. I got one from that I was recording while you guys were watching. We got Judge Wendy up in the house. This is a good one. This is a good one. Here we go.
Okay, we just need total attention whenever you're ready.
What is she
Yeah,
doing?
I'm ready. I'm listening. I apologize.
Okay, as long as you're seated, we can proceed. Thank you.
Thank you.
Oh, good Lord. Oh my God. Mute, please.
Let's just mute Miss Dover, please.
You think, Judge?
Billy Dover versus Kellen Brinson, plan across the street.
Good morning, Ms. Six.
Morning, Judge.
For the record, this is a Zoom hearing. Firstly, President Mr. Kellen Brinson this morning. The President signed the court show cause docket. Is that correct, Ms. Six?
That's correct, Your Honor. He was on the 8 a.m. show cause docket today.
We can provide some the files across the streets. Can you provide the court some basic information, Ms. Six, in terms of the current support obligation, the amount of arrears, the last payment?
Certainly, Your Honor. In this matter, we were last before the court on March 27th for a contempt proceeding after Mr. Brinson had been arrested on his bench warrant and afforded a court-appointed attorney. You did find him in contempt of court on March 27th. It was a first finding of contempt. He had already been in the jail for 7 days, so he was given 7 days immediate jail credit for 7 served in order to pay $1,000 prior to today's court hearing. As this case has a current monthly support obligation of $990 per month. The arrears balance is currently $14,438.68 if we do not count April's support. And the last payment was received December of 2022.
You received nothing since March 27th, since Mr. Brinson was released from jail. Is that correct?
That is correct, Your Honor.
Right. So you're asking that Mr. Brinson be ordered to serve additional jail time?
That is correct, Your Honor.
Right. For the record, in addition to Mr. Brinson, Billy Dover is also present. Before we hear from Mr. Brinson, we'll hear from Ms. Dover. We'll unmute Ms. Dover.
Sorry, you were muted. I apologize.
Okay, Ms. Dover, is there anything you want to say? Ms. Hicks, the attorney for the front of the court, is recommending that the court impose additional jail sentence on Mr. Brinson since he's not paid a dime in child support since December of 2022.
He hasn't paid since December because Kellen, which, from my knowledge, our caseworker is aware. I can't remember his name, but the gentleman that Kellen has worked a seasonal job for quite some time now, and if you look back in his payment history, you'll see that he doesn't pay in the winter so much, but he did give me money yesterday after I called in because I told him I was going to. If I didn't get it by a certain time, this way I could guarantee that he gave me some money out of the $300 check he did just receive. And I don't see why putting him in jail is going to do anything. It takes more than just money to raise the kids. I do definitely need money by all means, and I would appreciate quite a bit more. But my boys also do need a father, and him going to jail with Kellen's already background and history doesn't really show them. I mean, the man that
Mr. Brinson,
they really should see out
Mr.
of him.
Brinson, Ms. Dover,
Yep.
Mr. Brinson, he's ordered to pay child support to the front of the court, not you directly. So are you willing to come down in front of the court this morning? Hold on. Ms. Dover, are you willing to come down in front of the court this morning and waive some of these arrearages?
I have to go to the library and I'll be down there today. Not this morning, but I will be waiving what he gave me, not some of them, just what he gave me in cash, which he gave to me because I needed for a bill.
Okay, and how much did he give you in cash yesterday?
$240, and he only got a $300.
I'm sorry. How much did he give you yesterday?
What's up, Christina?
$240.
Yeah, and he only
It's
got
an
a
Irish
$300
demon.
check.
Okay, so you'll be coming down to the courthouse sometime today to waive $240 in arrearages. Is that correct?
Yes.
Right. All right, Mr. Brinson, you have there's no order that says you paid directly to Miss Dover. You ordered to pay to the front of the court. So there's records. So if she didn't waive those arrearages, you're out of luck. You don't get any credit for that $240. Understand that.
Yes, Your Honor.
Okay, you need to get, I told you, not once, I'm sure more than twice, you need to get a full-time regular job. The front court is a 4-page list of employers that are screening for employees. I give you a job today. Mr. Brinson.
Yes, sir. Yes, Your Honor. I have the list, and I called Jack. Yes, Your Honor. I have the list of employees.
Jack's hired you today?
They didn't hire me. They said they weren't hiring currently, but they will be soon. I work for an employer. It's called Nirvana. It's a marijuana dispensary, but I was supposed to be getting hired in, but I have a felony on my record, so they can't hire me yet, I guess.
There are employers in this list that are hiring people with felony convictions.
Yes, Your Honor.
You're not trying hard enough, Mr. Brinson.
Yes, Your Honor.
When did you last consume alcohol?
2 days ago.
Okay, you got money for alcohol, but you don't have money for child support.
Correct.
Why should the court not send you back to jail, Mr. Brinson, to get a job?
And I don't help as much as I should financially, but I do help with my kids and my granddaughter.
You have $14,000 of arrears. You have no obligation to support your granddaughter. You have to support your own children, Mr. Brinson. You have to pay to the front of the court.
Yes, Your Honor.
You're not getting any credit for money paid directly to the mother of the children, Ms. Dover.
Yes, Your Honor.
Ms. Brinson, you leave the court with very, very few alternatives.
Sir, he did want to pay it to you guys, but I needed that money. I couldn't wait the week and a half, 2 weeks for it to process through.
Could come down this morning right now and weigh those arrears, Ms. Dover.
Well, like I said, I'm not going to sit here and fib to you. I'm not going to come right now. My boys aren't even in school yet. They don't start until 9. They go to Custer. So I'm fighting with them to get ready and doing this, but I will be down there today.
Right, Ms. Hicks, at least Mr. Brinson is here this morning. I'd rather him go out and spend 8 hours today looking for a job. And the court's likewise very frustrated with him. And perhaps a short adjournment and have him contact, I don't know, multiple employers each day. I'm open to any suggestions.
That would be agreeable, Your Honor, but it also might behoove him to file a motion to modify. It's currently charging at $990 a month. Every month that he does not pay, almost $1,000 is getting added onto this arrears, and it's already at just under $15,000. With once he doesn't pay in April, we're at $15,000 in arrears. This is a prime case for the Attorney General to end up charging him with a felony. So while he's here in the court, maybe he needs to come downstairs and file a motion to modify his support. If he's not working a job where he can afford to pay $990 a month.
Yeah, it's a good suggestion, Mr. Brinson. Did you hear that? Go down to front of the court today. You have no job. Do you go to Nirvana today, or you have no job to go to today?
Not today.
Okay, what about the seasonal job you said you had? What's
After I got locked up, I was supposed to be going back there, and they haven't called me yet. I don't know when work picks up. Hopefully.
Well, you need to call them. You should call them every day.
Excuse me.
If you're motivated, then call them every day. So go down to the front of the court this morning, file a motion to reduce your support obligation.
I'm sorry, excuse me.
The only reason I didn't file a motion to reduce it before is because I believe my kids do deserve that amount in money, but I just.
And it's clock. You click along $1,000 a month, Mr. Brinson. You're digging the hole deeper.
Yes, Your Honor.
Sir,
Yes, Ms. Dover.
can we put in there that Kellen is to have a paper from the Pro Concrete stating that he did go up there, speak to the owner to get his job back or start working, because that is a job that Kellen can do. He just has to straighten up his act. I like I said to the lady before, I'm not going to sit here and BS any of you. I mean, I know Kellen can do this. He just has to get himself together, and he has a great job with Pro Concrete. But he has to speak to the owner, Dennis, and prove himself, which is something that Kellen should be doing.
You hear that, Mr.
I believe
Brinson?
he should be able to, give you guys some type of proof that he's done that, and that they still, or that they said no or yes to a job.
All right, Mr. Brinson has heard your comments, Ms. Dover, and hopefully he'll follow through with that. At this time, the court's going to adjourn the matter. And the court's going to, I'm strongly suggest Mr. Brinson file a motion to reduce your support. Maybe it goes down to $600 a month or something. Right now, $500 a month. Right now, your income, you don't have the income to pay $1,000 a month. This is not going to go away.
$16 an hour.
And the
That's
front of the court's
McDonald's
going to,
money.
hold on, Ms. Dover, hold on. The front of the court, the Attorney General, once he gets over $10,000, They are looking at cases, they're gonna charge you with a felony, non-support, felony criminal charge of felony non-support. Then you're looking at some significant jail time, if not prison time, Mr. Brinson. Say goodbye to the relationship with your children. And I'm just telling you, you're pushing really close. So I strongly recommend that you file a motion to reduce support, and it'll be based on your current income.
Yes, sir.
And also, I'm going to order you get a copy of the job list. I want you to contact, go back to your employer today, your former employer, Pro Concrete. I'm going to order you in the meantime, you contact 5 employers per day until you have a job. There's a form he can obtain, right, Ms. Six, and that employer can sign the form that he contacted them today, and they have nothing available.
Absolutely, Your Honor. I can have that out and waiting for him when he comes back down to the window.
So, Ms. Brinson, you're gonna spend 8 hours looking for a job. So you're gonna contact minimum 5 employers per day until you have a job.
Yes, Ron.
5 per day.
Do I need to bring that?
Starting today. No, you're gonna kind of get it back to Ms. X. So what the court would suggest is go down and file a motion to reduce support this morning. Get a hearing date. The hearing date's gonna probably be a month off. In the meantime, go talk with Pro Concrete, your boss there. That seems like a good paying job.
It is.
Meantime, get this job list and go to Jack's Lawn Service and fill out forms they're not hiring. Go to Michigan Bar, they're not hiring. They're hiring dishwashers. These are good paying jobs. You go through the list and you got to get 5 a week. If you're not on the list, go to Kroger's, go to Big Dog, as if you're doing seasonal work, landscaping.
I have a cousin that works there.
Okay.
Go to
5
Wendy's,
per
go to
day starting
Chick-fil-A,
today, Mr.
work at a
Wilson.
bouncy house.
So we suggest German not to exceed 30 days, Ms. Hicks. And hopefully
yes,
that
Your
Mr.
Honor.
Ritz will come back to the job and we'll have filed the motion to reduce the support obligation.
Do you want me to place him back onto my docket at 8 a.m. in the morning, Your Honor?
That's fine. I'll always be available if you want to elevate it.
Correct. May 23rd at 8 a.m.
Ear model.
Okay, Mr. Brinson, you order to appear before Ms. Six, May 23rd, 8 a.m. In the meantime, you order to get a copy of this job posting list. Contact, we're gonna give you a form downstairs. We can go out this morning and contact a minimum of 5 employers per day. Start today. So by the end of the week, you will contact 20 employers. I'm sorry, there's only 4 days left of this week. Yeah, so to 20 employers to have a job. And once you have a job,
You understand you do have the right to have an
you
attorney.
don't need to contact any people. Again, the court suggests contact your Pro Concrete people. That's a good paying job. If they probably just want you to show up on a regular basis, right?
Yes.
Go to Harbor
And
Light.
stop
If
the
you
drinking.
have trouble with your drinking, get some treatment. You're too young. You're going to destroy your life, Mr. Brinson. And every time, of course, there's an incident between you and Mr. Over and you're arrested for PPO violations because you're intoxicated, right? Come on. You're a good person, Mr. Brinson. Just get your act together for the benefit of yourself and your children. So, Ms. Six, will you notice it's May 23rd, 8 a.m. Do you have any questions?
I do, sir.
Ms. Dover, you have a question?
Instead of it being a job history, can we just ask for him to go to AA meetings every day? Because he can have his job back at Pro Concrete if he straightens his act up. Dennis will be happy to bring him back on, but he doesn't want him drinking. I mean, I would appreciate that more than the job searching for a job.
This is not a criminal court, Ms. Dover. That's out of my bailiwick to order him. I'm strongly recommend that to him, but this is not a criminal charge. I can't order him to engage in treatment. I've recommended it before. I'm recommending again that he go to A meetings.
Like I said, I was just asking. I
That'll help
wasn't
you
sure.
get a sponsor. They'll give you a sponsor. That's what you need. You've heard it from more than one source. Mother of your children, the court. Right, anything further, Ms. X?
Further, Your Honor, I'll prepare that order and upload it, and I have those forms waiting for him for when he comes back down to pick up.
All right, thank you, Ms. X. Sorry, Mr. Prince, go down, wait for the court, and those forms will be available. Start the job search this morning. You'll get a copy of the order May 23rd, 8 a.m. to appear. If in fact you not pay anything, I'm telling you, you're going to come back before this court later that morning, and you have 38 days to have your head. 30 days. You're not even tell to another corporate attorney. There's never been a finding of contempt. It's just a matter of when you serve you control the key to the jail, Mr. Brinson. I'd rather be out working, especially with spring here, than sitting in jail, supporting your children. Do you have any questions? Okay, all right, you're all set, Mr. Brinson.
Thank you so much.
You're welcome. Please take advantage of this opportunity. Okay, all right. And
It's DeSanto time.
All right, thank you. And you heard the plea that your attorney indicated, correct?
Yes.
And as to the allegations that you tested positive for alcohol on March 24th, failed to agree for drug testing on April 5th, how do you plead?
Guilty.
And you understand the rights regarding probation violations, correct?
Yes.
Can you sign this document?
Yes.
And prior to signing the document, you read and understood each of those rights.
Yes.
You also understand by entering into plea, you'll be waiving some of those rights, specifically your right to a contested hearing.
Yes.
You understand the possible penalty as a result of your plea, whether in this court, any other court, if you're on probation with any other court or administrative agency. Do you understand that?
Yes.
And knowing all that, do you still want to continue with the plea?
Yes.
You also understand the recommendation here.
Oh, keeper! Everybody, keeper, you're healthy, darling. Keeper is back. Guys, if you could find the link, I think it's in Legal Stuff's Discord. I was going to mention this today, but she's here. If one of my mods want to go get the link in Legal Stuff's GoFundMe, you want to help out Keeper, there is a GoFundMe through Legal Stuff. I'm more than happy to put it in my chat. Keeper is part of this fam.
Here, where it's recommended that probation would be continued and you'd complete all terms of probation, $50 probation violation fee, and 30 days on the alcohol tether. That's the recommendation.
Yes.
And Tim, that's a recommendation only. This court does not have to adopt it in full, could adopt it in
Yes.
full, or could not adopt it at all.
Yes.
And knowing all that, you still want to continue with your plea.
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
All right, counsel, if you can please respond to your client.
Sure. Mr. Mullins, is it true that you're currently on probation out of the Wyandotte District Court?
Yes.
As a term and condition of probation, are you to not test positive for drugs or alcohol?
Yes.
Did you in fact test positive for alcohol on March 24th of this year?
Yes.
You understand that that's a direct violation of your probation?
Yes.
What did you consume that made you test positive?
Alcohol.
What type of alcohol?
Everything.
Liquor.
What type of liquor?
Fireball.
Approximately how many shots of Fireball, if you recall?
4.
Judge Mom is not amused. She's got the lip. That's where she bit her tongue, literally. Fireball. What a dope.
And did you fail to submit to a drug test as ordered on April 5th of this year?
Yes.
You understand the failing
Heather!
to submit to those drug tests when ordered is a direct violation?
Yes.
Satisfied, Your Honors.
The court is also
Tasha, what's
satisfied
up,
the plea is
nerds?
knowing, voluntary, and factually accurate. The court will accept your plea to the probation violations, indicate that a plea of the probation violation will enter based upon.
Thank
the plea of
you,
guilty
Billy
as to
Buzz.
violation number 2. And counsel, as to the recommendation.
Yes, Your Honor. I truly don't believe that this is going to be an issue again for Mr. Mullins. After speaking with him at length, I do believe I put enough fear in him with the threat of potential jail time for any further violations. He understands that. He is gainfully employed. He does not want to end up there. So at this point, I just simply request that the recommendation be adopted on behalf of my client.
Sir, what was the occasion that you decided on, I presume it was March 23rd, but was it March 22nd? What date?
It was the day before.
Okay, so what was
It was
going
just
on?
a hard day at work. Super day. Okay. I worked 16 hours and I just went home and had a few shots.
Okay,
There's the whispering.
and you've been on probation since December 19th, or January 9th, correct?
Yes.
So you're very well aware that you're not to consume any alcohol.
Yes.
So what was kind of going through your mind as you were pouring your shots, drinking your shots?
I was just thinking I had a long day and I just trying to relax. And I was strong, but it's not gonna happen again.
And why did you not appear at your testing on April 5th?
I forgot to call on that day.
Would you have tested positive on that day?
No.
Okay, sir, this is your one shot. Number one, you're gonna have an alcohol tether for 30 days. If you violate that, you'll be incarcerated for the balance of that. If you violate again, you could be serving jail time. Quite frankly, you will be serving jail time, especially if it's for the same type of violation. You're on probation for operating while impaired by alcohol. You cannot consume alcohol. You can't just touch negative. You can't consume it.
All right.
The court's going to indicate you're to continue to complete all terms of probation, pay a $50 probation violation fee and 30 days on the alcohol tether. And so you're going to have to go see Mr. Roberts to get that information regarding the tether. The court will note these are your first violations. That doesn't mean that you can continue to violate without consequences, sir. The consequence this time is an alcohol tether. Next time, is through those doors.
Thank you, Judge.
All right, thank you. You have a seat over in probation, sir, okay? Thank you. Good luck to you. All right, this is the matter of the city of Wyandotte versus Amar Ferrara.
Oh, I think we got a good 12-month hearing going on. We're gonna go to that one.
Good morning,
Let's
sir.
go to 12-month.
Your name for the record, please.
My name's Amar.
While I'm pulling that up.
All right, and sir, you have signed this waiver of attorney, correct?
Right.
You understand you do have the right to have an attorney. Thank you. And that there is an attorney here that can represent you.
Yes.
And you're choosing to represent
Jimmy
yourself.
Gunn or Gwen?
And that's for both the arraignment and the free trial, correct?
Yes.
Okay.
All right, and sir, do you understand what you're charged with, or do you need the court to read the charges that you're charged with?
I understand what I'm charged with.
Okay, you understand the possible penalty, correct?
Yes.
All right, so you want the court to waive the formal reading and continue with the proceedings?
Yes.
Court waive the formal reading, enter a plea of not guilty for purpose of the arraignment.
Okay.
We'll
Do
do a
you
little
have an
Amarillo
operation
while I'm
vehicle
pulling up the
expired plate
12-month.
from December 28th of 2022? Not guilty, no contest, or guilty?
Guilty.
Okay, I'm going to go ahead and find you guilty. You only get 1 day jail credit. I see you also have a blue warrant. Is that correct?
Yes, ma'am.
Do you want to remand yourself? You'll have this served out tomorrow.
Yes, ma'am.
Okay. Deputy's going to give you a voluntary remand form saying that you're remanding yourself. I figured you'd probably get this resolved before you get your blue warrant taken care of.
Okay.
Okay, yeah, because you just have enough time that you'll serve it out tomorrow. Okay, so, but make sure you sign that before you leave. The deputy's going to bring that to you. So, okay, thank you.
Thank you.
Mr. Patterson?
Yes, ma'am.
Mr. Patterson, on August 28th of 2019, you were charged with the offense of, for the animal Donna, not having the tag or the vaccination. Do you want to plead not guilty, no contest, or guilty? Those are city ordinance violations. Guilty? Okay. I will find you guilty. Looks like you just get 1 day jail credit. Do you anticipate being there any longer than today?
No.
Okay.
Turkey Trail. Okay,
And
so
I
I
would
got
like
this
for
from the
us to
beginning.
address time for the hearing. We do.
Okay, so I'm getting this from the beginning. This is rolling right now. So we'll catch up. We'll go through the parts. Let's have some fun with this 12-month hearing. Let's go.
You have several witnesses, including a couple that are on call that we will
require specific times and that you comply with specific times. That this is a very full calendar, please. So we'll go ahead and go forward with it. So does that address?
Especially said we had thought Judge Edgerton was going to hear it because he said it. I guess
when we reset it, it's reset onto a regular calendar.
Okay.
We can actually do it differently than that, but that's okay because we're here today. Judge Edgerton is not here.
Judge Dude is not here.
Does that address your question, Ms. Heinsohn?
Yes, it does, Your Honor.
Did you have anything else before I move over and see what Ms. Hood wanted to address?
No.
Okay. And Ms. Robinson Roberts and Ms. Hood, anything from your side we need to address or clear up?
Nothing at this time, Your Honor.
Oh, we got a team working.
Okay. Well, since I'll just go in the orders of the case filings, and if I could, I'll just go ahead and start with allowing the attorneys for John Dixon can give me a brief opening, and then I'll let Ms. Heinsohn speak for Ms. Moore, and then we'll jump right in. I'm just good. The way I do these whenever there's a cross petition is just put up your cases. Okay, and just make it as you go rather than us being distinctive and breaking it down and making it more confusing than it needs to be, okay? So go ahead. I don't know, which one of you is going to give the opening?
I'll be giving the opening.
Okay, all right then, Ms. Robertson Roberts, go right ahead.
Thank you, Your Honor. The evidence to be presented to the court today will show that Ms. Moore has committed a statutory act of family violence against my client that has occurred repeatedly in the past and is therefore likely to occur again in the future, and therefore a 12-month TPO is necessary to protect my client. The evidence will show that the parties are currently husband and wife. They've been married for 1 year and 3 months. There are no minor children of the marriage. As you can see, Mr. Dixon is elderly, he's 77 years old. Ms. Moore is 25 years his junior at 52 years old. My client will testify that she frequents the gym for weight training 4 times a week. The evidence will show that Ms. Moore preyed upon my client for his wealth after the death of his previous wife of 53 years.
Ooh, we got a
and
gold digger!
Shortly after their marriage, she began using violence and intimidation to keep him under her control and to keep control of his money and his assets.
Gold digger!
We have our client testify about how Ms. Moore used violence to isolate him from his friends and family, to control his interactions with members of the opposite sex. She coerced him into making large purchases, including satisfying the mortgage on her premarital property, purchasing 2 additional properties in cash, transferring $100,000 of cash into her account for what she claims to be was to care for him in the event that he were to become incapacitated. You will also hear how Ms. Moore began physically abusing my client on a regular basis and what she would call her black spells, and using the threat of violence to get him to deny to his friends, his family, and even the police.
Black spells?
During one attack, she violently beat him while he was asleep, causing him to have impaired vision. Another attack, he was admitted to the hospital. We have a recording, we have medical records, and we have pictures in support of my client's testimony. You also have the testimony of Mr. Dixon's sister about what she's witnessed. The most recent attack.
Okay, I need all hands on deck here. Moderators, people in the chat, this is way ahead. We need to, get coordinated here in Discord and get this chopped up recorded so we can get this whole thing. I'm going to show this. Let's speed it up. Let's do whatever we can, and then we'll put this together because this is going to cut on us. Let's go.
Against my client, which led to Mr. Dixon filing for this TPO occurred on March 27th, which was 3 days after he was released from the hospital for internal bleeding. The evidence will show that Ms. Moore spent the night out the night before. She returned the next morning, immediately began attacking my client as she was led into the home. And despite him begging and pleading for her not to hit him as she's done in the past, she began hitting him in the face, chipped his tooth with a ring. And the evidence will show that the police were called. Ms. Moore left the residence, returned 2 days later with an entourage of about 4 police officers and a group of friends to get her belongings while he was home alone. Somehow, also, the spare key for the new locks that my client installed after the attack disappeared as well. Despite the evidence that you'll see and hear from my client today, Ms. Moore and her attorney will present evidence that they will discredit my client and disprove his allegations. They submitted an affidavit and recording. And what I will ask of Your Honor today is to pay close attention to the circumstances surrounding the creation of that evidence, especially the tone of the recording that they will submit. And you will hear that not only did Ms. Moore engage in abusing my client, but she also engaged in designing a plan to cover it up. While my client has filed a case for elder abuse with the DeKalb County Domestic Violence and Elder Abuse Unit, a 12-month TPO is necessary to protect my client. He's in extreme fear for his safety. Based on the evidence and testimony to be presented today, we're asking that the terms of the ex parte TPO be extended to a 12-month protective order. We're asking that it be expanded to include an order that Ms. Moore paid $1,000 towards the homeowner's fees and expenses for the properties that they own, that Ms. Moore be ordered to attend a batterers intervention program and follow the recommended treatment. We're also asking that Mr. Dixon be awarded attorney's fees in the amount of $10,130.50 to include the last appearance and today's appearance, as well as preparation for both, pursuant to 19-13-4-A10. As the court is aware, Ms. Moore has also filed her own TPO against Mr. Dixon. Her TPO is baseless, lists no specific allegations of acts of violence against her whatsoever. Closest she gets to this is by stating that my client, popped up at her residence unannounced. The evidence will show that that statement is not only false and misleading, but that the residence that she's referring to is what was a marital residence up until only a few months ago, and that she only resumed residing at that residence after the entry of the underlying ex parte TPOs. As she alleges no acts of family violence whatsoever, Ms. Moore requests for an extension of her TPO should be denied in its entirety, and that's what we're asking the court to do today.
All right, thank you very much. Ms. Heinzen?
Yes, Your Honor. Our position is that the opening that you heard is a complete fabrication of a story that is completely untrue. These parties got married in December 2021. They have known each other for like 4 or 5 years. When they married, my client had a business that she has given up so that she could travel with Mr. Dixon. The marriage happened less than a month after he had broken off wedding plans to which he had invited other people to celebrate. The pattern is that Mr. Dixon gets angry. I believe I am not a psychologist, but his behavior seems to be narcissistic. When he does not get his way, he gets angry. If he feels rejected or challenged in any way, he gets angry, leaves, breaks up, becomes verbally abusive. 2 or 3 days later, stalks my client, follows her, texts her, shows up at her gym, shows up at her place of residence. My client has owned a condo in Dunwoody for a number of years. Mr. Dixon has pursued my client relentlessly during the year of 2021, trying to get her to marry him after he broke up a relationship with another woman in February of 2021, having planned a wedding with her. He made false police allegations against the woman that he broke up with in February of 2021. She was accused of stealing jewelry that he had given her, continued to purchase gifts for her and pursue her, even offering to buy her a white Mercedes if she would get back with him. So Mr. Dixon, for whatever reason, since his wife's death in 2018, wants to be married, and he has been obsessed with my client. My client does not have a history of violence. There will be evidence that she does not have a history of violence. Mr. Dixon gets in her face, threatens
we see her.
that he's going to take her furniture that she had premarital, that he's going to take her condo. He does things like buy real properties and put it in joint names. He leaves, he breaks up. He then says, if you'll come back to me, I'm going to buy you a car. Mr. Dixon filed for divorce with Katie Cannell in February, 2 months after this marriage, less than 2 months after this marriage in December of 2021. That case was dismissed 4 days later. And he's pursuing at that point my client to reconcile. It's a very
thank you, Basia.
Emotionally abusive, intimidating situation for my client. My client's error is that she didn't have the good judgment to run and flee from him as a result of this volatile behavior. He went to the hospital to document physical injuries that he alleges that my client inflicted almost 2 weeks. He reported to the hospital almost 2 weeks after the injuries. The same day he went to an attorney, Justin Hayes, to the attorney contacted my office and was going to file elder abuse charges. This elder abuse has not happened. Family violence is not happening in this case. This is a case where the parties need to be divorced. We filed for divorce, and the divorce is pending. They, I believe, have acknowledged service and have entered an appearance in the divorce. Mr. Dixon, in pursuit of my client, he promised her love, take care of her. You need to leave your business. You can travel with me. I'll put you on my joint account. Why do you need your own credit card? Why? He's basically put her in a position of being very vulnerable to him and dependent on him. He has in fact purchased a Mercedes for her, which she did not want. He similar to his offer to the prior woman. So, Your Honor, our position on this is that it is a complete fabrication. We have an affidavit as one of our exhibits, which the other side has seen, that Mr. Dixon signed in December of 2022, saying that his wife had not beat him up and that the person that he told was fabricating it. This is 2 months after he went to the hospital and reported that his wife had beat him up. So the police officers that came to the condo on the incident with the police report that both parties have submitted, the police officers saw absolutely no injuries to Mr. Dixon, despite the fact that he is on Xarelto, a blood thinner. So, Your Honor, the only conclusion that I can make is that Mr. Dixon is attempting to either intimidate Ms. Moore, who is an immigrant from Brazil. She is not, this is not her native language, her native culture, or her native environment. He is trying to intimidate her, either out of some emotional need of his, or in part to gain a financial advantage in a divorce proceeding, rather than, these parties entered a settlement agreement a year ago to dissolve their divorce, and then he pursued her to reconcile. So, the first lawyer that he hires accuses Ms. Moore of a shakedown. Subsequently, Ms. Moore, was perfectly willing to be divorced, and Mr. Dixon continues to pursue her. So my client, he has been going to the church that she has attended with her friend, despite a history of not attending church. She is in the Dunwoody area. She's afraid to go to her gym. She's concerned that he is going to show up somewhere in her environment. She's been avoiding all those places. But at this point, my client would like to be divorced from this man and would like for him to leave her alone. He does have a history of stalking her when they are broken up, and we would like for the 12-month order to be enforced because of his threats and intimidation of her. So respectfully, Your Honor, that's what we believe the evidence will show today.
Okay, thank you very much.
Excuse me, Your Honor.
Yeah.
I'm sorry, before we proceed, after hearing both opening remarks, I was able to hear Ms. Henson very, very clearly, kind of from her environment and her cadence. If Ms. Roberts in her colloquy, in her office, it's a little bit more cavernous there. If she could be a little slower and deliberate in her arguments, I'd be able to hear it much better in terms of getting her down verbatim. I just wanted to say that.
All right, thank you. We'll have her get closer to the mic. Thank you very much. All right, let me go ahead then and turn it over for Ms. Robinson Roberts for you to call your first witness.
I'm going to call John Dixon, Your Honor.
All right, Mr. Dixon, if you'll raise your right hand, please. Do you swear or affirm any testimony you're about to provide this court is true and correct under penalty of perjury? All right, and Mr. Dixon, I'm going to ask that when you speak up as much as you can, okay?
Oh, we got a birthday shout out. Shout out to Mama Katie. She's a wonderful mom, and today's her birthday. It's Ariadne. Love you. Happy birthday, Mama KT. Ariadne. Happy birthday, Mama KT. Thank you very much for the dono. Let's roll.
Thank you. Go ahead, ma'am.
Thank you, Your Honor. Can you please state your name for the record?
John R. Dixon.
And what is your relationship to the respondent?
She's my wife.
How long have you and Ms. Moore been married?
We got married December 24th of 21, so that's about 16 months.
Okay, and are there any minor children of this marriage?
No.
Where do you currently reside?
4561 Old Perimeter Way.
Is this where you, I'm sorry, what is the city and state?
Dunwoody, Georgia.
All right, and is this where you and Ms. Moore lived together before you filed for this TPO?
Yes.
Has Ms. Moore committed any acts of violence against you?
Yes.
Has she done so on more than one occasion?
Yes, several.
Okay, does she usually attack you randomly, or is it when she's upset about something?
Objection, Your Honor, leading the witness.
I'm going to sustain that objection.
Oh, here we go. This is going to be lovely.
Under what circumstances has she committed an act of violence against you?
When she gets very upset, she does it. And in fact, she's done it on occasion when she wasn't so upset. I still don't even know the reason.
On what date was the most recent attack?
March 27th of this year.
And where did that take place?
At our home, 4561 Old Perimeter.
All right, and let's go ahead and discuss the surrounding circumstances and events that led up to March 27th. Can we start with March 23rd? March 23rd, where were you on March 23rd?
March 23rd, was discharged from Northside Hospital.
All right, and why were you in the hospital to begin with?
I entered the hospital through the emergency room on Monday the 20th, and I was admitted because, well, to back up, on March 15th, I had double hernia surgery.
Ooh.
And it was outpatient surgery, and I was home and I was not doing well. And so I went to the emergency room on Monday the 20th. My blood count was half of what it should be. My heartbeat was double what it should be. I ended up staying to get blood transfusions the 21st, 22nd, and the 23rd you just asked about. I was discharged from.
Were there any changes in behavior or any incidents that occurred between you and Ms. Moore while you were in the hospital?
Yes, I need to go back and do a little detail. I entered the emergency room on Monday the 20th, and Allie, Ms. Moore, my wife, she was at the hospital with me until about 11 and she left. And I remained in the emergency room until about 3 that morning getting transfusions. And they finally took me to a room. Tuesday morning, about 8 o'clock, a doctor was sent up by the emergency room, and she had figured out she thought what my problem was. And she came and explained it to me. It made good sense, and I was happy to hear it. It didn't sound as serious as what I thought it was going to be. And she left the room. And then later in the day, sometime in the afternoon, and my wife Allie, there's no chance she was going to be there in the morning. She always goes to the gym. And in the afternoon, she came, and my surgeon came in, and he was talking with me. And I asked my wife to write down the surgeon's name as well as the name of the doctor that had been there that morning. She took it upon herself to look up the doctor that she didn't meet that morning. It was a female doctor, and she became very, very upset that I'd been in the room with a female doctor and not chaperoned.
All right. Was this typical behavior of Ms. Moore when it came to you interacting with other females?
Absolutely. She didn't want me in the room with a female. She didn't want me in a car with a female. She didn't want me to talk to a female for any reason without someone else present.
What about female family members?
Well, I have two sisters, one 85 years old, one 80. And pretty much all contact with those two sisters has ceased. Allie didn't want me to communicate with them at all by any means.
Right. Do you have any children, Mr. Moore? I'm sorry, Mr. Dixon.
Yes, I have two. I have a daughter, 43, and a son, 49.
And what are their names?
My daughter is Holly McMillan. My son is John Dixon.
All right. And how is your relationship with your children?
It's not good right now, and primarily because even though they've never met, they very much objected to our marriage and our relationship. And because of that objection, they've pretty much severed relations with me.
What about the relationship between Ms. Moore and your children? Was there?
Miss Moore's never met either one. She's begun talking to my daughter back around October, November, primarily because my daughter had told her, and I forget exactly whether it was an email or a text or what, I don't know how they were even communicating, had told her that if and when I died, I think everybody's assuming I'm going to die before them, but if I died and she attempted to be heir to anything I may leave, that my daughter and her brother would see Miss Moore in court to try and protest Allie receiving anything.
All right. Have you ever faced any consequences for interacting with another female from Ms. Moore?
Consequences? Yeah, she's slapped me on the head several times. She has a signal she tells me is very common in Brazil that she uses to, if a female's even in the room. If I'm at a traffic light and a lady walks across in front of my car, she becomes upset. She accuses me of lusting after a total stranger that's simply out walking.
All right. Had Ms. Moore been physically violent towards you before the March 27th attack?
Yes, several times.
All right. How frequently would you say that she's been physically?
Every month or so, there's usually an incident.
All right. I'm going to direct the court's attention to Petitioner's Exhibit 1. It's a recording.
All right. Madam Clerk.
Good recording.
Can I ask that we start at the 3:08 mark? I think there's a lot of.
I mean, there's 3 minutes of him in his pocket.
Ms. Heinzen, have you had a chance to hear this recording?
I've heard the recording, but I'm not sure about what happens before 3:08. I really want to make sure that the court hears the whole recording. I know there's some rattling around at the beginning.
All right.
I don't know I'm not sure what of the dialogue that they're cutting out if they go to 308.
Okay, let's back it up.
Terrible. I have the entire thing recorded. I'm caught up. I'm live on my other recording device. We will have this whole TPO today. Go ahead, cut it. Did he just fart? That was a burp? Gross. Ugh. That's the worst. Is he in DeSanto's chair? One word, dude. Prenup. Could have avoided all this. Oh man, noises. .308. I think we could have went to 408 at this point. Does he think he was recorded something? Batch fart scrimmage. How is this relevant? If you see the comments, I'm trying to like do other things and I read in the comments. It's so funny. You guys are the worst. Wow, this is captivating. Did they?
Get your stuff out of here and move to the other room. This side of the house is gonna be mine.
Do what?
Do not provoke me tonight.
Okay, you want me to get my stuff out of this home?
I want you to get your clothes off and go to your room because I'm on this side of the house from you.
Oh.
That's all.
That the toilet seat?
You're gonna use this bathroom here, please? Do not shit all over like you do every bathroom. Okay? Do not use this bathroom here. Use the other house. I have the right to have one side of the house. Fuck. You're gonna regret this. But this time, John Dixon, I'm not coming back. Okay? And you're gonna say okay, but you're gonna regret deeply because I took care of you. I took care every day of you. Every day. You know what? You know what?
No, don't hit me. Don't hit me.
You know what?
Don't hit me.
Do not provoke me.
Please don't hit me.
Okay?
I think I'd have to go back to the hospital. I'm serious.
Do not provoke me.
I'm trying not to. I'm trying to be very quiet.
You're a mean guy. You're a
drinking?
mean guy. No, I didn't. They can come here right now 2 beers. That's
Well,
not.
that's drinking.
That's not drinking.
Well, for you it is.
Oh, that was great. Guys, you should see what the rest is coming. This is going to be fantastic. Is that Salma Hayek, by the way? That sounded like Salma Hayek. Don't shit. Don't shit in this toilet. This poor guy probably makes a cool $5 million a year and he can't even take a dump in his own house. Oh, please fart again.
Right, Your Honor. I can either lay more foundation for the recording, or we can tender it without an objection.
All right, Ms. Heinzen, any objection?
No objection.
All right, it'll be admitted without objection.
Okay, Mr. Dixon, what were the circumstances that led up to the events in that recording?
That recording was made on March 25th, Saturday. It was actually my first day of actually getting out of bed, being able to walk around much. I was very weak, totally exhausted from blood loss. And if I recall correctly, Allie was still very angry about the female doctor that had come into my room unsupervised with me. And she was showing her anger.
All right, can you explain to the court and give the court a sort of visual of what was actually occurring during the recording?
Well, during the recording, she gets, and she's done this many times, but I remember that recording. She gets right in my face and shakes her finger at me, and usually talking the way she was talking there. And it very often leads up to her starting to hit me and so forth. And right at the end of that conversation, she spit in my face. And that's when I went into the kitchen and got away from her.
All right. When was the first time Ms. Moore ever became violent towards you?
First time I remember very well was in July of 21.
All right. What were the circumstances leading up to that time?
My late brother's wife, who doesn't live in Atlanta, was visiting here in town. And I was going, and she had asked me to have lunch with her. I've known her for 50 years. And I was going to go have lunch with her, and I was leaving the townhouse where Allie lived, and I was currently living pretty much full-time also. And she was very upset that I was going to meet a female for lunch, even though it was my sister-in-law that I had known for 50 years. And right before I walked out the door, she hit me several times. I don't remember how many times, in the face with both of her hands, knocked my glasses off onto the floor, bent them. I had to get my glasses and reconstruct them and put them on. My glasses are this type that I have, may have been these exact ones. I scratched my face, and she immediately calmed down. When she saw she had actually heard me, she calmed down. We didn't have any angry words. I said, I gotta go, and I left. That was the first time. After that, I asked her, I said, is this something, it's the first time I've seen you like this. Is this something that happens a lot? Has it happened in the past? And she told me that it had. It happened in the past. She called these spells her black periods or black zones. She said, when I get into my black zone, I don't realize totally what I'm doing. And she admitted to it. I said, well, what am I supposed to do when you act like this?
There
this comes
she
about.
is, Mikey.
And she said, talk me down, try and calm me down. And I said, okay, I'll try that.
Have you ever suffered physical injuries from any of these attacks?
Yes, that was one, and it wasn't severe, but my face was scratched from my glasses where she was hitting.
All right. And in your petition for this TPO, you listed an attack that occurred in January of 2022.
Yes.
Can you explain what occurred?
Yes. It was either her day of her birthday or the day before. It's the 21st of January. And she and I had driven from Atlanta to St. Petersburg, Florida to celebrate her birthday, just to take some time off. It'd been a long drive. I drove all the way, which is fine. I enjoy driving. We got to St. Petersburg, checked into a hotel, went across the street, had a very nice dinner, very casual. We were enjoying ourselves. Went to the hotel. We had a room with a suite, 2 rooms.
He annoys me. He's a whistle talker. He's a whistle talker.
And it was probably getting to be 8, 9, 10
She's
o'clock.
not 28.
And she said she was going to take a shower, and I said, I'm just tired from driving. I'm going to lay down and go to sleep. And when she was in the shower, I laid down in the bed. and went to sleep. And I really don't know how long it was. It wasn't terribly long. I woke up, she had thrown the bed covers back off the bed and was punching me in the face with both hands. And as you can imagine, it was a great deal of a surprise. You know, first I had to figure out where I was and what I was doing because I was asleep in a strange hotel. But I woke up and I got up and to stop her to continue hitting me, I put my arms around her, tried to hold her arms. And I didn't hold her long, just a few seconds really, and I thought it'd stop. And I let her go. And with that, she started hitting me again.
Stop
Second
talking.
round. And I put my arms around her again and held her. And after that, it subsided. We stopped. I went into the living area to get away from her. She went into one of her raging, cussing, screaming sessions. I just stayed in the living area. I ended up sleeping in the living area that night to stay away from her. The next morning, I heard her in the bedroom packing, and I woke up. And when I woke up, I realized my vision was broken. And it was, I felt sure as a result of her punching me in the face several times. She finally became, she got packed up, and I assumed she was leaving. And she came in and sat down, and we talked very calmly. And I told her my visions for her, and I said, I think I should go to the emergency room. And she we didn't say anything right away, but we talked about it. She didn't want to go. She realized the emergency room would say, what happened to you? And she didn't want to report at the emergency room that she had been hitting me. But we talked and talked very calmly during the day. She didn't leave. We spent the day together, got back on speaking terms, so to speak. As the day progressed, my vision cleared up, and by that night, my vision was good. That was pretty much the day. It was either her birthday or day. I forget which.
All right, and you also mentioned an incident in November of 2022. Can you explain what happened during that incident?
That was probably October of 2022. It was an incident where she and I had been out to dinner, and we'd gone to Capitol Grill in Dunwoody. We'd had a very nice, pleasant dinner, had no discussions of any kind that would lead you to believe anyone was upset. And we were leaving the restaurant, and it may take 5 or 10 seconds to walk from our table to the exit door. So, I mean, we were in the restaurant leaving 5 or 10 seconds. As we left and entered the parking lot, she started screaming and yelling about how I had been staring and lusting after a table of women in the restaurant. And she was saying that in that 5 or 10 seconds, I was able, in a dimly lit restaurant, to identify a table full of women and begin lusting after them. And we continued walking to the car. I walked her to the car. I opened the passenger door. And as she got in, she kicked me in the ankle. She went on, got into the car. And as she got into the car, she slapped me in the face twice, knocked my glasses off onto the asphalt. I closed the door, got my glasses, walked around to the driver's seat, got in the driver's seat. And we only lived 5 minutes away. And during that 5 minutes driving to the townhouse, she started punching me in the arm several times. I don't know, whether it's 2 times, 5 times, 10 times, I don't know. Many times. And as a result of that, my ankle continued to get worse and worse. The ankle, it got very painful to the point that I was limping. But
did you tell anyone about what occurred?
yes, a couple of weeks after that, it had gotten to the point I could hardly walk. I went by my sister's house again. And my sister worked in a hospital for 40 years. She's not a doctor or a nurse, but she certainly had a bit of exposure. And her son's a doctor, but he wasn't there. And she said, you need to go to the emergency room. You could have a chip bone, you could have a fractured ankle, you could have a broken ankle. They may want to put an air cast on it. And so I took her advice. I went to the emergency room. And they x-rayed it, determined it wasn't fractured or broken. No chip bones.
About how long after the incident would you say it was before you went to the hospital?
It was about 2 weeks.
And why did you wait that long before you?
Well, as I said, the day that it occurred, it wasn't that painful, but it got more and more and more painful.
I'm going to direct the court's attention to Petitioner's Exhibit 2.
All right, Madam Clerk, Petitioners 2. And Ms. Heinzen, have you had a chance to review this?
I have, Your Honor. I have no objection.
Thank you.
Admitted, Your Honor?
It is.
Were there any visible injuries from this attack, Mr. Dixon?
Well, there was, and as Ms. Hansen pointed out earlier, at that time, I did take a blood thinner. My ankle was very obviously injured. It was blue and swollen, and my right arm, where she had punched me so many times, was very bruised, blue, and very, very tender.
Okay, I'm going to direct the court's attention to Petitioner's Exhibit 3.
Petitioners 3, Madam Clerk.
What page would that be on?
It'll be under Petitioners 3. It's a different document.
Your Honor, just while there's a pause, I just want to say at the end of Mr. Dixon's testimony, I'm going to need to get a couple of name clarifications if I can. Just wanted to put that out there.
Absolutely. Thank you, sir.
Oh, you see that, people?
Be under the same document, page 32.
Ms. Roberts.
Yeah.
Would this be it? Because I only have two.
This is Petitioners 3. Yes.
Yes.
Okay, so under the same document. Thank you.
All right, Mr. Dixon, do you recognize these pictures?
Yes, that's a photograph I took of my arm. And matter of fact, I know where I was sitting on the bed in the guest room of our townhouse.
And what was the date that this picture was taken?
Late October.
There should be another picture that's part of Exhibit 3 also. And I think there's a third one also of this ankle. Right. And is that a true, and are these pictures true and accurate depictions of the condition of your ankle, your arm, on the dates that you took the pictures following the incident in October 2022?
Yes, they are. I took those pictures myself.
All right. Have you altered these pictures in any way?
No.
All right. Move to admit Petitioner's Exhibit 3.
All right. Any objection, Ms. Heinzen?
No objection.
All right. They'll be admitted without objection.
Right. Now, Mr. Dixon, after these attacks or during these attacks by Ms. Moore, have you ever retaliated or hit Ms. Moore back?
Never.
Now, after these incidents, have you and Ms. Moore had conversations about them, about why they occurred?
Yes, as I said, I asked her, how should I react to these spells that you have, what you call your black zones or so forth. And as I told you, she said to talk me down, try and calm me down. And I attempted that sometimes.
Right. And has she ever engaged in any activities that could be perceived as trying to conceal the abuse or cover up the abuse?
Well, she went to Brazil in November. I forget the exact dates. But when she came back, she and one of her lady friends went to her attorney's office, and they were very concerned about my children, trying to prove her. Are you going to say something? She was very concerned about my
Objection,
children.
Your Honor. If he's testifying about about a conversation he was not part of.
I can't.
Is that what's happening, Ms. Robinson Roberts?
I had a conversation with Allie about this.
He's
Well, she told me about the conversation. True.
Okay, then I'll let it in.
Okay.
She told me she and her friend had gone to Miss Hanson's office, and she was very concerned about if I were to get hit by a bus, that my children would in some way implement her in my death due to the fact that she wanted inheritance and they wouldn't get it and so forth. So but at this meeting, she told me that Miss Hanson and Miss Hanson's legal assistant, I don't know her name, and her friend had all said, you've got to get something in writing from him. You've got to get him to write down that you didn't do these things.
Objection about that's hearsay and not a conversation he was part of.
Yeah, I'm hearing like levels of hearsay here. So let's just keep it to exactly what Ms. Hineson's conversation with him was about.
Who told you this information?
He didn't say he was at my office. He said it was her and a friend.
Yeah.
No, I didn't say I was at.
Where did you hear this information?
Miss Moore told me.
Okay. And so what was it that they?
Well, she was telling me this because she wanted me to write some kind of document saying that she had never harmed me in it.
Did she ask you to do that?
Yes, she did, and I was very reluctant to do that because it wasn't true. She said I have to have something, and she kept on and on about it. I mean, she went to sleep at night talking about it. In the morning before she got out of bed, her feet hit the floor, she was talking about it.
So did you sign a document?
I did sign the document, and I've asked her how she wanted it worded. The document did me no good. It wasn't for me. It was for her future defense, if you would say that, in case someone accused her or something. But
what is in the document?
Well, the document, I was very careful how I worded this because I wanted to make sure that it wasn't totally true. The document says she didn't beat me up or she didn't beat me. And that's true. She didn't beat me up. And that's why I could make myself sign it. But in fact, if someone asked me, yes, she has hit me, she has kicked me, she has slapped me, and all these other things. But no, she wanted this document that she could pull out after my death to show people that I had said she didn't beat me up. And I was able to convince myself to do that based on the wording of it.
Did you know you were under oath when you signed that document?
Yes. And I was under oath, and I told the truth.
Okay. When did you sign this affidavit?
December 6th.
Of what year?
22.
All right. So this was after the incident where you.
It was about 2 months after the actual incident, after the incident where the kicking and hitting and all
that. Okay. What was your reason for signing that affidavit?
Well, as I said, it didn't mean no good whatsoever. It could never do me any good. I was doing it because she wanted it. It made her feel comfortable in case of my death. She would have it to defend herself from my children and still be able to claim some part of my estate, whatever.
All right. Did she make any promises to you in exchange for signing?
Well, she's promised several times, but that time she promised she'd stop the violence, she'd control her temper, and be a little more cautious.
All right. Now let's return to the events of March 27th. previously testified that you were released from the hospital on March 23rd. You were at home on March 27th. Is that correct?
That's right. The 23rd was a Thursday. I was discharged from the hospital. I still couldn't, I had no energy. I was totally exhausted from blood loss. That was Thursday, and Friday I was still in bed. Saturday, the 25th, was my first day out of bed. And that was we heard that recording earlier. And then Sunday, the 26th, I was up and down. And she had left on the 26th.
All right, before we get to the actual events, can you explain to the court if there were any changes in her behavior or any indication that?
Well, that entire week, earlier I said I went in the hospital on the 20th, which is Monday. On Tuesday, the 21st, after she went to the gym that morning, that afternoon she came out of the hospital for a couple hours, and she was dressed beautifully. By the way, she looked like a model. She was gorgeous. She stayed at the hospital a couple hours and went out that night with somebody. I have no idea where or what. I do know that I was trying to text her around 10 or 11 o'clock and she wasn't answering. That was on Tuesday, the 21st, 22nd. Pretty much the same routine. She came out of the hospital in the afternoon for a couple hours after she'd been to the gym. And again, dressed beautifully. She was gorgeous, looked like a model. And she went out. I asked her where she was going. She never answered me. She went out that night somewhere. The next day, the 23rd, was the day I was discharged from the hospital, and she met me at the front door and drove me home. And she stayed home that night. Then the night of the 24th, which was Friday, she again went out. I have no idea where she went. Night 25th, the next day, Saturday, again, she went out. I have no idea where she went, what she did. The next day, Sunday, 26th, I noticed she was packing a bag, and I asked her where she was going. And I remember her telling me it was none of my business. She left 25th Sunday and didn't return that day. She came, the next time I saw her was on Monday, the 27th, about 10:30.
All right, and so what happened then around 10:30?
Well, I was up, I was moving around. And the morning of the 27th, I heard somebody beating on the front door. And I went to the front door, and we have a lock, we have a deadbolt, and we have what's called a door jammer. And I had the door locked. I do it every night when she's there, when she's in there. And she had managed to unlock the locks, but the door jammer was keeping her from coming in, so she was beating on the door. I let her in, and she came in the door screaming, yelling, cussing, and swinging. She pretty much came in the door, hitting me and punching me. And my first response was, I'm going to call 911. I'm going to call 911. And I headed to get my phone out of the bedroom we use in the office, and with her beating me, hitting me all the way to the office. And in that I'm going to say beating, one of her hands, I don't know which one, had a ring on, hit me in the tooth, small chip on my tooth. I managed to get her, and she was trying to take my phone away from me because she's done that many times in the past. And I managed to push her out of the bedroom and close and lock the door, which allowed me to call 911.
All right, let me just back up just a little bit and ask you about the attack. Was she hitting you in the face, or?
Well, she was attempting to hit me in the face, and I was holding up my arms like this. Of course, she was just hitting my arms. But if I hadn't held my arms up, she would have hit me. And she did hit me a couple times in the face, I know, in the tooth. And when I got into the bedroom and sat down at the table I use as a desk, I held my feet out like straight like this. My legs longer than her arms, so that I could keep her at bay doing that.
And what was her? You said you testified that you told her that you were going to call 911.
Right.
Did she have a reaction to you telling her that?
Well, she was still cussing and yelling and screaming, and I'd gotten her out of the room and locked the door, and I called 911.
Have you ever threatened to call 911 in the past after?
Many times, many times. In the past, every time I've threatened, not threatened, attempted, she took my phone away from me. And she's, at least 5 times she's taken my phone away from me. 2 of those times, one time she threw it on the hardwood floor and damaged it. Another time she slammed it on the table and damaged it. And the other 3 or 4 times she just took it away from me and didn't allow me to have it back until she saw fit.
Okay. And so where the attack is happening, you're trying to get to the bedroom. Were you afraid of her at that point? How were you?
I was very afraid of her. She's very violent. She's very physical.
Did you, how did you react? Did you hit her back?
No, I've never hit her. I've never hit anybody.
How about Miss Moore? Are you aware of her ever having any violent relationships with anyone else?
Well, I've questioned her about this because I was concerned about our relationship. She told me she had violent relationships with her first husband, her second husband, her daughter. She told me she and her daughter had a physical fight as they were driving down the interstate, which is pretty scary. Told me she had violent fights, physical fights with her older sister. And I mentioned her first husband, her second husband. She also told me that she had physical fights with a fiance in Portugal and with her 5th husband. And now I know she's had them with me, her 6th husband. So there's at least 7 people that she told me that she's had physical or violent.
Okay. I have the rest. It's not unavailable. So what I'm going to do is as I get this up and running, we'll go live somewhere else and I'll get this up and running for you and then we will play the rest. Okay, so here we go. Okay, so this is what I'm going to do. I am going to take a break. And then I'm going to let this roll. I'm going to go back up. Just watch for my notification. I am not going to cut in on Credence and Mikey. So if they are up and running, you're going to go to them. I'm not going to be live at their time, so I'll be on right after them or a little before. So just give me a couple minutes and let me go through this, and I will be back. All right? Here we go, people. I will see you soon. You have been halfway served.